Welcome again to Clearview, our public enlightenment program. I am Ojon Bello. This week, we want to give a clear view to a landmark legal tussle between National Human Rights Commission and Professor Osunbor. Remember him? He was governor of Edo State. There was a suit against him over electoral offenses, but now the suit has been dismissed. The Federal High Court in Abuja has quashed the indictment of former governor of Edo State, Professor Osunbor, by the National Human Rights Commission, NHRC, for electoral offenses. It also declared as null and void the report of the commission and its recommendations, urging the Attorney General of the Federation to prosecute him for electoral crimes. Osunbor, who was sworn in as governor of Edo State on May 29, 2007, was sacked in controversial circumstances by the Court of Appeal in 2008 after 18 months in power. However, in 2014, the Governing Council of the NHRC recommended the former governor and 40 others to the Attorney General of the Federation for prosecution for an alleged violation of electoral laws and commission of other criminal offenses. The recommendations, which the Commission said was from the Council's consideration of an independent review of evidence of gross violations of rights to participate in government, were said to in the exercise of its powers under Section 6, Subsection 1 of its NHRC Act 1995 as amended. This made Osunbor to go to court to declare that his purported indictment by the Commission for Electoral Violence was unlawful and unconstitutional because the Commission did not give him any opportunity to defend himself before arriving at the indictment.
Well, I'm very glad with this development. It has been years of struggle to clear my good name. As you will recall, in April 2014, the National Human Rights Commission, just from nowhere, announced that they had indicted me for electoral offense and that they had written to the Attorney General of the Federation that I should be prosecuted for electoral offense. I wrote to them demanding whether what I read in the newspaper was true and what offense I had committed for which they had indicted me. They more or less admitted that they had written, yes, it was true, they wrote to the Attorney General, but they didn't tell me what offense I committed. I then took them to court since May 2014 for the court to quash the report and claiming so many other reliefs. And over the years, they tried to obstruct my efforts to have my human rights protected and ventilated. But finally, as you know, last Friday, the Federal High Court, Honorable Justice Ojukwu, granted the reliefs that we sought. One, that it was a violation of my fundamental human rights for them to indict me without even any reference. They didn't invite me for any investigation. No fair hearing. Well, first of all, that the indictment and recommendation to the Attorney General was ultra vires, was unconstitutional. Two, that they violated my fundamental right under Section 36 of the Constitution to fair hearing. And three, that they had no right to investigate electoral offenses. That is the function of INEC and the Election Petitions Tribunal. National Human Rights Commission has no power under their Enabling Act to investigate electoral offenses and to punish people for electoral offenses. Whatever they are, observers don't have the right to convict, to find people guilty and to indict people. If they are observers, they are observers. Observe, but you don't have right to indict somebody, an innocent person, for the commission of an offense which you failed to disclose to the person. And they claimed that they reviewed the tribunal judgment that removed me from office and that the tribunal did not go far enough. And so they were recommending that I should be prosecuted. And of course, the Federal High Court said that the National Human Rights Commission, being an executive arm of government, has no right to review the judgment of a court or tribunal lawfully set up and to arrive at a decision different from that reached by the court or the tribunal. Otherwise, one day, even when the Supreme Court says Mr. A has won the presidential election, if they are not checked, they will say, no, the Supreme Court was wrong and that it's Mr. B that won the election. That would be treading on a very dangerous terrain. So I'm happy that the court has checked them to say they have no right to review the judgment of an election petition tribunal or even to prescribe punishment for people, because that is the responsibility of tribunals, not them. And the court granted perpetual injunction restraining them from further publishing the report or circulating the report or taking any action either by themselves or their privies in furtherance of the report and indictment which they reached, because it was illegal. So that is the development. And I think it is very significant in the history of Nigeria, in our political evolution and the evolution of our jurisprudence in Nigeria, that the National Human Rights Commission of a country like Nigeria has been found guilty of violating the fundamental human rights of an individual. It's a major scandal. It's a major embarrassment. Because when good laws are made in Nigeria, people who are supposed to implement it, they change it completely and use it for a wrong purpose. An example is the pensions. This pension, people thought, let us reform the pension process, Pension Act in Nigeria, so that pensioners can have a better deal. But some people had turned it into something else completely. The human rights, government had a good intention, good objective in setting it up, but some individuals decided to manipulate it, change it, and to use it to reach an end which was not contemplated when it was being set up. So I think that is a major lesson. What the Human Rights Commission has did to me is not an isolated case. They had done it to other people before. And what they usually do is that they are protected by the Public Officers Protection Act. The Public Officers Protection Act says that no action can be brought against any public institution or public officer unless you commence the action within 3 months of the act complained of. So whenever they do something, they will wait until maybe less than a month, let's say 2 months and a week or some days before they publish it. Because there's also a provision in their act which says that you cannot sue unless you give 1 month pre-action notice to a number of people, the chairman of council, the executive secretary, and members of staff. So what that means is that if they have committed a wrong, they keep quiet. When they know it is like 2 months and a few days, they will then publish it. When it comes to your attention and you want to go to court, they will say you didn't give them 1 month notice. And if you give them 1 month notice, then it will exceed the 3 months that you are allowed under the Public Officers Protection Act. Do you understand what I'm saying? So through that, they've been getting away with a lot of things. Even in my case, in my case, they raised that objection. So rather than come to court and tell the court, yes, they stand by their report because Osunbor did this, Osunbor, they didn't do that. They were raising preliminary objection that they were entitled to 1 month pre-action notice. The first judge that handled it agreed with them and struck out the case that I didn't give them up to 1 month pre-action notice. But I said no. The commission as a separate legal entity was not named in the Human Rights Act, National Human Rights Commission Act, as one of those to be given pre-action notice. The section talks about member of council, executive secretary, staff, but not the commission as a separate legal person. So the Court of Appeal agreed with me and remitted the case back to be heard on its merit, to be assigned to a different judge. So that judge now looked into the merits of the case and said, yes, the National Human Rights Commission violated my human rights in doing what they did. So your question is, what then can we do to avert this kind of wrongdoing? The first one is that it is good to expose the people behind what has happened, because they hide under the cover of immunity and anonymity, because it's the commission that I have sued. But there were people who were behind it. The people were the chairman of the governing council at that time, Professor Anselm Chidi Odinkalu. He was the chairman of the governing council. They presided over this thing. The executive secretary, Professor Bem Angwe, who was the one always announcing on television that I had been indicted. And then thirdly, one Professor Johnson Udombana. He was the one they brought to write the report for them, to say that I was indicted for electoral offense. None of these people showed up in court. Almost 10 times that we went to court. It is now the commission that is bearing the shame and the embarrassment of what has happened. So how do you check these things in future? Is to ensure that you remove this immunity, this Public Officers Protection Act. Yes, and there are efforts ongoing to review the Public Officers Protection Act. This act was introduced during the colonial period in order to protect colonial officers from prosecution, from local people, the native people then. But under the modern democratic dispensation, there's no justification why you should be giving pre-action notice. If I'm going to sue you, I won't give you pre-action notice. If I'm suing AIT, I won't give AIT pre-action notice. So why must we give National Human Rights Commission pre-action notice, or anybody there? So it's an unfair protection which they enjoy, which encourages the impunity and their violation of the rights of others. So what government should do is to set in motion the process of amending, in fact, the National Assembly, of amending all those laws which unduly protect public servants and public institutions and encourages them to perpetrate this kind of impunity. And then secondly, for government to be very mindful about the kind of people they appoint to certain sensitive positions. There are certain very sensitive positions that are too big for certain people. And when they get there, you find that they are overwhelmed by the enormity of responsibility of those offices. It's not enough for somebody just to answer professor. And then you say, oh, he deserves, you look at the kind of person that he is. So I believe that as we evolve our processes, we begin to put square pegs in square holes or round pegs in round holes, and improve on our laws, especially those that tend to encourage or protect impunity on the part of people in government. Well, this, there's one thing, like what I just told you, there's one, you look at the laws, reforming the laws. Secondly, is the individuals that operate the law. And I think we are beginning to see in this country, people have been saying that Nigeria's problems is not lack of laws, but faithful implementation of the laws by the individuals who are supposed to implement them. Like the Administration of Criminal Justice Act has been introduced to speed up trials for criminal offenses, but this one was it's a civil case. And we came by way of originating summons. You can start a case either by originating summons, which is applicable where you don't intend to call witnesses. Because in our case, we just invited the court, look at the documents that these people prepared, study it, and say whether they had the power to do what they did, vis-a-vis the Constitution and vis-a-vis the National Human Rights Commission Act. I didn't have to go into the witness box, so that's originating summons. The other is writ of summons, where you'll be calling witnesses. So somebody can call 10, 20 witnesses, and that will drag on for years. The advantage of originating summons is that you just invite the court to study the document, and that shouldn't take time. But unfortunately, it took time in my case because the first judge was granting adjournments at least 7 or 8 times at the instance of the National Human Rights Commission. They did everything they did to deny me the opportunity to protect my human rights through these adjournments and raising objection that we should have given them pre-action notice and that we should have come by way of writ of summons, not originating summons. But the court said, looking at the affidavits, all the papers you filled, there's no contradiction, there's no conflict between what both of you are saying. It is when there is such conflict that you call witnesses to be able to find out the truth. Where you are not calling witnesses, then originating summons. But as I said, the first judge sided with them, upheld their objection, and struck out my case. I went on appeal. The appeal court said, no, it was wrong. This case must go back to the Federal High Court, assign it to a different judge, and hear it. That was in June this year. The courts went on vacation soon after that. I believe maybe in September, it was reassigned to another judge, and within 2 months, she delivered judgment in the case. So would you say that that was because the law was defective? So that was not due to a defect of the law, perhaps due to the decision, the discretion of the first judge who had the case, which we filed in May 2014, only now to be decided, concluded by another judge on its merit in December 2017. So as I said, for our processes in Nigeria to be okay, it is good to pass the law. The law is basic, but it is also good to look at the character, the qualities, the integrity of people that you are appointing into these offices. Because no matter how good the law may be, if you put somebody there who shouldn't be there, then your efforts in making good laws would have been in vain. Society will not derive the benefits of all those who participated in the process of making the good law, or even making the Constitution. When I was in the Senate, I was my second term in this, even the first time, I was a member of the Senate Committee on Judiciary, Human Rights, and Legal Matters. That's 1999 to 2003. In 2003, during my second term, I became the chairman of the Senate Committee on Judiciary, Human Rights, and Legal Matters. I handled a lot of issues pertaining to human rights in Nigeria, including even setting up the National Human Rights Commission. I represented Nigeria at the United Nations Conference on Human Rights in Geneva in 2004 and 2005. So I am not a stranger to the issue of human rights. That is why I say I know the objective that government had in mind in setting up the Human Rights Commission. But that objective is being debased, is being jettisoned by other considerations. I mentioned to you the individuals who did what they did, not only me, to other people. And you begin to wonder what was their motive, what was their reason, why did they do this? As professors of law, don't they know about fair hearing? Because even undergraduates in the university know Section 36 of the Constitution, know that you cannot indict somebody without giving him an opportunity for fair hearing. Even market women, people on the street, they know you don't indict somebody unless you have given that person opportunity for fair hearing. Even in our local customs. So professors of law, Odinkalu, Bem Angwe, Odombana, what was propelling them that they overlooked this aspect of the Constitution and the law? I don't know. I hope that people who know them will ask them even if it is in private. My friend, why did you people do this to this gentleman? Is it because he's gentle, he will not fight you people? Or was it, just to let them tell the world why they had to indict an innocent person?
Well, with that interview, we end this week's edition of Clearview. I am John Bello. We want to believe that you'll join us same time next week for another edition of the program. Bye for now.